In a majority verdict, the Supreme Court upheld the centre's 2016 decision to demonetize 1000 rupees and 500 rupees currency notes. The 5 judges bench of the Supreme Court pronounced its judgment on a batch of 58 petitions challenging demonetization. Justice B R Gawai, while delivering the verdict on behalf of the other judges, said that demonetization cannot be struck down on the grounds of proportionality and decision-making process cannot be faltered merely because the proposal was from the central government. Justice Gawai further said that it is not relevant whether the objective was achieved or not. Justice B N Nagaratna gave a dissenting judgment. Justice Nagaratna said if at all the centre needs to demonetize currency notes, it should be by way of legislation or an ordinance in case secrecy was needed and not through a gazette notification. Earlier, the Supreme Court had directed the Centre and the Reserve Bank of India to put on record relevant papers relating to the government's 2016 decision and reserved its verdict. It also heard the arguments of Attorney General R. Venkataramani, the RBI's counsel and the petitioner's lawyers including senior advocates P. Chidambaram and Shyam Diwan. Calling the scrapping of 500 and 1000 rupee currency notes deeply flawed, Mr. Chidambaram had argued that the government cannot on its own initiate any proposal relating to legal tender without the recommendation of the RBI. However, the Reserve Bank of India had said that demonetization was done based on its recommendation. The RBI had earlier admitted that there were temporary hardships, but there were also mechanisms by which the problems were solved. In an affidavit, the centre told the top court recently that the demonetization exercise was a well-considered decision and part of a larger strategy to control fake money, terror financing, black money and tax evasion.